Tonight, as I said for my intro, I'm going to look at the long residence route, 20-year route to an indefinite leave to remain or to leave to remain. Obviously, everyone's aim is to eventually get indefinite leave to remain. So tonight, I'm going to look at three things. I'm looking at private life in terms of those who have lived here for either up to 20 years or less than 20 years. And then I also look at what the Secretary of State considers to be exceptional circumstances and what amounts to what they call compelling factors. So tonight, I want all of you to obviously share the link, because this is a very topical area of the immigration law, long residence. And it's an area where most times becomes a last resort for a lot of people. And most times, even when people want to rely on long residence under the private life to regularize their stay after living here for 20 years, there is still an insurmountable obstacle in terms of evidencing how that person has lived here continuously for 20 years period. And one of the reasons why some people might not be able to demonstrate that they've been here for 20 years. So tonight I'm going to take my time and gradually explain to viewers and listeners how one can regularize their stay if they have lived in the UK for 20 years. I'm doing this within the confines of the law. So I'm going to look at the immigration rules, and I'll look at the casework guidance. And obviously, I don't come here to speak fiction. I speak facts. So I'll look at the relevant case laws, recent case laws that people can rely upon even when they are not able to evidence their continuous residency in the UK after they have lived here for about 20 years. So I'm urging you, obviously, to get ready tonight. And if this is the first time that you have joined us tonight, we do this program every Tuesday in English, and on Thursday we do it in Tree with MC Chaka. So tonight I'm going to be here alone, and I'm going to take viewers gradually and look into the long residence route to leave to remain. This program is proudly brought to you by City Law Solicitors. And you can also watch this program on City Media TV, on Facebook. You can watch the program on YouTube, City Law Solicitors channel. You can also watch it in my own profile, on my own profile. But I urge all of you who have been watching this program on my own profile to please kindly migrate to watch it from the City Media TV, because eventually I will not be broadcasting my shows on my own profile, because all the programs will come to City Media TV. That's where all the action, the epicenter, everything will be taking place. But for now, I'm urging you to migrate. And above all, you can also watch this program or listen to this program, City Media Radio. And I know that there are lots of you out there who have been here for 20 years. I speak to prospective clients all the time, And I understand their anxiety and their frustration. It is for this reason that I have put this program together. For all of you to be able to benefit from it. To give you hope. Not false hope. Hope based on the law. And that is why all of you should, in fact, one way or the other, benefit from this program. Because if you don't have any of these issues, a friend of yours or a family member of yours may have some of these issues. And tonight is about you watching me tonight. It's about helping you to regularize your stay within the confines of the law. It's about making law affordable to you by giving you this free legal advice. Proudly sponsored by City Law Solicitors. And as I go for a short commercial break, just to enable viewers to know what City Law Solicitors, our sponsor, does, and within a matter of a minute, I'll come back and I'll gradually take viewers through this topic, the long residence route to live to remain, or the 20-year rule to remain, and how people can also rely on exceptional circumstances or compelling factors in their life to make application outside the immigration rules. Yes, you can make application outside the immigration rules. So, after a short commercial break, I will take viewers through these 3 topical areas under the private residence rule or the long residence rule of the immigration rules. Don't go away. Just bear with me. In the next 2 minutes, I'm going to take you through this topic. Thank you for your patience. As I said tonight, I am looking at immigration tonight, and I'll be looking at the long residence route, the 20-year long residence rule, and what it means. And for those who have also been here for less than 20 years, what they can rely upon to be able to regularize their stay. If it is the first time that you've just joined us, I want to repeat that we do this program every Tuesdays and Thursdays. On Tuesday, we do the English section, which is what I'm doing tonight. So tonight is the English section. And on Thursday, we have the same topic, but in Tree, and it's hosted by MC Chaka. So on Thursday, MC Chaka will be here for us to look at the same topic that I'm looking at tonight in the Tree. But as I said, this program is about you. It's about making law affordable. It's about giving you free legal advice. It's about assisting you to regularize your stay, and above all, to take that anxiety and stress from you by giving you this advice that you may need badly, free of charge. Now, when we are looking at the long residence route, I must be specific here. I am not looking at the 10-year route to indefinite leave to remain when people have lived here lawfully for 10 years. When people live here lawfully for 10 years, I did a topic on this, and most of you who have been following us will be familiar with it. If you haven't watched one of the videos, you can also go back to our platform and you can watch it. So I'm not looking at those who have been living here lawfully for 10 years and are therefore entitled to an indefinite leave to remain. Tonight, I'm looking at private life. But even the private life, we have those who are under the age of 18, but less than 25, and have been here for half of their life. And they have now got a concession that after true renewal, which is 5 years, they can then get indefinite leave to remain. And there are kids who have also come to this country who are under the age of 18 and have been here for 7 years. And for that reason, they are also entitled to apply under the 10-year route. And those who are born here with both parents not having any leave to remain, who are also 7 years in this country, and previously they could apply under the 10-year rule, but now they can simply apply for indefinite leave to remain. So these 4 areas is not what I'm looking at. I'm looking at those who have lived here continuously for 20 years illegally. The underlined word here is illegally. You've lived here 20 years, 20 good years illegally. You have records under the law. There is a provision in the immigration rules, specifically paragraph 276 ADE. So you have records under that provision for application to be made for you to regularize your stay. This is a law that has been in place since the 9th of July 2012. So you can see why I'm doing this topic tonight. In the next 2 months, we'll have an anniversary, 10-year anniversary, since this particular law came into place. And I'm sure that previously, I've got caller.
Hello?
Hello.
Hello, the patrol legal hour.
Liga hour now was we.
Patrol radio car. The testimony being on pressure committee, Lawyer Thomas. The patrol second hour.
A quiet down, normally be a phone line, but what for over Simudia, over to me, across so why?
They say my clock Romuha, a quarter of years me, your friend marriage. My clock Romuha, me quite come a bema, and I will be doing me, sir, or land car tamani, our year. Now, so the Pacon wire and Cratan all day, 4J in a coy, and a mobile swimming almost say, a more family, and will be doing for them better. Lawyer Thomas, I'm not catching them and come to me. And say, I did me, 10 years of year. I am passing, you know, or they going in a 4 year. Now, so minimum choir, Nanko for far. So, Pastor Thomas, sorry, Lawyer Thomas, and wow, Boamino. They don't come in church and never to us, and Mount Famamia, or minimum 7 years, and never to us, and yes, the amount of 5 years into radio. They catch your beer, say, lawyer, and who do say, I want you to cast some about to a beer, what now, in our who say, do I know, right to be beyond Conor, intimacy of the American, Namin Shano.
But that's it. Why? Yavisha.
Okay.
Bye. Yes, viewers, this is one of the clients. I think out of excitement, he decided to call to give testimony tonight. And I'm sure that the Bible basically that Jesus Christ delivered a lot of people, but eventually only few of them came back to give a testimony. So testimony is good. It gives encouragement to those who have lost hope. Obviously, it rekindles the spirit of those who are also looking forward to something positive. So it's good that he phoned in to give this testimony. But tonight, I am here for you. I am here to advise you, to give you, explain the law to you. This platform, we explain the law. So as I was saying, I am looking at those who have been here for 20 years and have said that this comes under the private life. But the point here is that there will be those who have been here for less than 20 years. There will be those who have what they call exceptional circumstances, and those who have compelling factors. And I'm going to take my time to explain all these areas within the confines of the law. And I must emphasize, we operate within the law in a sense that the Home Secretary have laid out a law, legislation, and there are immigration rules, and there are guidance to assist caseworkers in making decisions. And therefore, lawyers are meant to make those representations and submissions looking at the circumstances of their clients, such that they will be able to make those cases to appeal to the Secretary of State within the confines of the law that their clients deserve to be granted leave to remain. And it is for this reason that I'm taking my time to explain why most of these applications are refused. I normally get those who, after going around, they come back, they come to us, and then straight away, we're able to establish why those applications were unsuccessful. And it is for this reason that tonight I'm going to take my time to treat this field advice. Now, for those of you who want to make application under the 20-year rule, if you look at the paragraph 276 ADE subsection 1 to subsection 4, it's laid out quite clearly that you must have lived here at least continuously for 20 years. You must not be also refused under the suitability requirement. And I'm going to take my time to explain that as well. And it should also be the case that you face an insurmountable obstacle of being integrated in a country that you came from if you were to leave the United Kingdom. I am not the one saying this. This is the Secretary of State's Immigration Rule, Section 276 ADE, subsection 1 to subsection 4. So first, let's look at the word continuously living in the UK. Again, the definition of this continuously means a lot. What it means is that you should not have been removed under Schedule 2 of the 1971 Act or Section 3 of the Immigration Act 1999, sorry. Or if you should not have been removed, for example, if you were coming to the UK and then you were returned. And for those who leave voluntarily, you must, for this continuous residence to be broken, you should not have had reasonable prospect or intention of coming back. It means that if you went and there was intention for you to come back, then your continuous residence will not be broken. Recently, I was dealing with a gentleman who obviously was enlisted for a program, but because he needed to have a visa, he was meant to go back to Ghana and come back in within 6 months. And he did quite rightly so, came back. There is evidence that when he was going to come back because the program that he was meant to be enlisted for required him to go back and go and get entry clearance visit visa from abroad. So such a person have left, but his continuous residence is not broken. The other section is those who, for one reason or the other, have been detained or imprisoned custodial sentence. We all know that offenses under the Immigration Act, for example, those who are working for one reason or other with a double identity or whatever, they could sometimes be apprehended and imprisoned, and they could serve custodial sentence for 6 months or more. With regards to those who have been imprisoned or are served custodial sentence, it is clear that your continuous residence will not break. However, it will be discounted when your 20 years residence is being taken into account. It means that if, for example, you came here 2002 and you've been here, let's say in April, we are now in May, so by now you have been here for 20 years. However, in the course of time, you serve custodial sentence of about 6 months. It means that 6 months that you were in prison will not count towards your continuous residence in the UK. But it will not lead to a break in your continuous residence. This is quite technical. However, it will be discounted. It means that you probably have to wait until another 6 months by discounting your 6 months prison sentence from your continuous 20 years residence before you will be eligible to make application under the 20-year long residence. But having said this, these are how one can evidence that they have been here continuously for 20 years without falling into any of these 3 areas that I have just enumerated. But it's also required that people need to show by way of evidence that they have been here continuously for 20 years. And sometimes, for example, every 6 months you may have to show some documents that you were living in the United Kingdom. And sometimes it's quite difficult for people to show that, because this is the person that perhaps is working illegally and therefore might not be able to adduce any evidence in his own name. But the law requires that he should show that he has been here for 20 years. Recently, I was talking to somebody who made application under the 20-year long residence rule, and the application was rejected. And then he went to the tribunal, and the case was dismissed. And he said that I just said that he could have returned to the country where he came from and came back to the UK. And therefore he does not believe that he has lived here continuously for 20 years. He's a lawyer, but how can the judge say that? I don't have paper, I can't travel, I've been living here. I said, yes, what that meant is that you have not been able to demonstrate that continuously you have lived here for 20 years because you don't have proof of address or sources of evidence to show your continuity of residence. That's what that meant. But I'm going to discuss a case law which is quite sensitive. So it means that most people have lived here continuously for 20 years. But there is a hurdle. Even though the Home Secretary, this law, immigration rules that came into place since July 9, 2012, which is almost 10 years that have been in place, they've made provision that if anybody have lived here continuously for 20 years illegally, then that person is eligible to apply for leave to remain to be under the 10-year route. This is the law, the provision that Parliament has put in place for those of you who, one reason or the other, either you came here with a student visa, eventually your visa expired, or you got married and your relationship broke down, you could not renew your visa. Look, sometimes people think that when people become illegal in this country, it's just because they just came through Cali and ended up illegally. Some people, for very, very, very sad reasons, become illegal. Some people, their relationship break down, their spouses are not willing to support the application, and they become illegal. And it is for this reason Parliament, in its wisdom, put in place that we want this to be a disincentive for people coming here illegally. But at the same time, we want those who have lived here continuously for 20 years also to be eligible to apply for some form of leave to remain. And after 10 years on that route, they will also get indefinite leave to remain. So this is a law that I'm just taking my time to explain to you tonight. It's not fiction that I've just given it out from imagination. But the point here is that most times, a lot of these people who have lived here for 20 years. The difficulty they have is evidencing, showing, demonstrating that in fact they've lived here for 20 years. Because sometimes it's quite amazing why the Secretary of State has made a rule, but sometimes most of these people cannot access medical health care. They are not able to work. They are not able to rent these days. So they might not even have tenancy in their names. They might not have bills. Yet the law is requiring them to provide the very evidence that the law forbade them from having. So you see the difficult conundrum for these applicants. And I just hope that somebody will share this video to that person who is in this difficult conundrum. Because that is the key. Now, in the year 2020, when we were when we first have the lockdown, there is this interesting case of Sultan Mahmood, a gentleman who have been in this country since around 1996. He has worked with people's documents. He's been arrested, released. She initially got married. His marriage didn't work out and became illegal. And then he started working in a restaurant with another person's documents. He made some applications disclosing that, look, I am Sultan Mahmood. I have been working with A's document all these years. And I've been going to my GP with A's document for medical care. And my GP knows that I am A, but in fact, my name is Sultan Mahmood. I'm giving you background of this case law, which is the key to unlocking that difficult conundrum to enable you to apply for leave to remain if you have been here for 20 years. So this Sultan Mahmood, and sometimes when I mention this case, those who are not updated with the law, they will say, oh lawyer, that's not right, it's not true. I'm quoting the case law for you. For those of you who are lawyers who sometimes watch me, you can go and check it out. So this gentleman, having accessed medical health care in A's name, having worked with A's name, but not in his real name because he's not eligible to work. When he made his application, after living here for 20 years, and disclosing that he is the same person who have used this person's documents to be working, that person who is a British, the Home Secretary, as expected, refused application on the grounds that it is false misrepresentation. And in fact, when there is misrepresentation, as I've said, the application straight away falls for refusal under the suitability grounds. So this gentleman's application was refused simply because he has disclosed that he has worked, because she couldn't show that he has lived here for 20 years by relying on any document in his own name. The reason being that the very law that requires you to provide these documents also forbids you from having this document, because currently you cannot even rent if you are living here illegally. Landlords are not supposed to rent out properties to you. You are not eligible to work. But when you look at the list of documents that the Secretary of State wants you to show that you have lived here for 20 years, it is the very document that is unattainable by those who are living here illegally. And it is for this reason that this application was refused. But let's look at what the upper tribunal decision said. the upper tribunal decision concluded that when you are making application under the long residence 20 years, what is required is for you to show that continuously you have been in the UK. And as long as you have disclosed that, even if you were working illegally with somebody's name, that you have made that disclosure, it means that you have not misled the Secretary of State. And you are not relying on that document for your leave to remain, but you are relying on it to show that you have been here continuously. And for that reason, the upper tribunal conclusion was that it was wrong for that application to have been refused, because the gentleman has not made misrepresentation, or he has not, in fact, it went further to say that he had presented false documents. And quite clearly, he didn't present false documents. The documents were in fact genuine. Another person's name, their national insurance number was genuine. That was the cause, the dicta of the upper tribunal. So it means that relying on these documents to demonstrate your continuous or continuity of residence in itself is not against the law, but absence of which your application will be refused. So for those of you who, one reason or the other, have been here for these 20 years and cannot evidence, and you find yourself in this difficult conundrum, the case of Sultan Mahmud quite clearly set out that any evidence whatsoever that you can rely on, whether in another person's name that you are using it to work, then you should be able to entitled or be eligible for that leave to remain, as long as you have not misled the Secretary of State and you have properly disclosed that, in fact, that was what you were using to work. So that's the point for those of you who are relying, who are stranded. I have clients who come to me and they have absolutely nothing in their name that they have lived here for 20 years. Yet most people are of this erroneous impression that mere living here continuously for 20 years entitles them to live to remain. It is not. And that gentleman I was talking to, he was so frustrated. And it took me almost 30 minutes to explain to him why, if he does not put sets of documents together to convince the Secretary of State how he has been living here continuously, then that application is bound to fail. And there are a lot of these applications that are failing. Yes, you are eligible to make that application, but it will fail because you don't meet the requirements. But don't lose sight of the law I have quoted to you tonight. Perhaps you can educate your lawyer about it to enable him to assist you with it. But that notwithstanding, there are those who have also lived here for less than 20 years. When you look at the same 276BE, the Secretary of State makes it clear that if once have been living here continuously for 20 years and does not meet that requirement, that application should be refused. And quite rightly so, because you don't meet the requirement. But there are those who have lived here for less than 20 years. The question is, how can you also make application? Because your case might be that you cannot even meet the 20-year rule. Talk of even showing that you have evidence to prove that you've been here for 20 years. Again, within the same confines of the law, it is quite clear that if refusing your application will result in unjustifiable, harsh circumstance, or put the Secretary of State in a state that it will be in breach of Article 8, then that caseworker should grant your leave outside the immigration rules or on human rights grounds. This choice of words is quite technical. Let me take my time to explain. So I am saying that when the caseworker have first considered your case and has found out that, one, you probably don't have evidence to show that you have lived here for 20 years, or two, because you have lived here for less than 20 years, then it is incumbent on that particular caseworker to look at whether refusing that application will present unjustifiable, harsh consequence to your life. And most cases, people make these applications without presenting their circumstances to the Secretary of State. The Secretary of State is not wicked as people think she is. But there is a law and guidance, and the hands of these caseworkers are tied to work within those guidance and the law. So it is for you or the lawyer dealing with your case to present that case to fit within the confines of those restrictions, so that that person dealing with your case can grant you the leave to remain. Recently, we were dealing with a case. My partner was mainly the one dealing with that case. And our clients presented certificate from the church. I said, this certificate is bound to fail. They made bookings to get married. They have a child in the relationship. We made application as a spouse or under the partnerhood. And the caseworker, I don't blame her, continuously making a case that our client should present marriage certificate. Our client cannot present marriage certificate, and the marriage certificate that he currently has in her possession is the one that issued by the church. I don't want to mention that church, but that church is not authorized to issue a certificate, recognizable certificate in this country. However, the law makes it clear that if our client is a partner, then he must bring evidence that they have lived together continuously for 2 years. But our client doesn't have this evidence, because where they were living, they could not be able to reasonably obtain those bills, and in fact, when they moved together, they kept their separate addresses. But they had a child in the relationship. Sometimes it is wisdom. So it means that if the child is just a year old, this woman would have fallen pregnant and carried the pregnancy for 9 months before giving birth. So by the time he gave birth to a child who is 2 years, it means the relationship has subsisted for more than 2 years, obviously. And it is for this reason that the caseworker, by presenting this argument, has to grant our client what he was looking for. It's about you understanding the law and making that case for your client. So the point here is that when people don't meet the 20-year rule, And there is a provision that if they don't meet the rules and refusing that application will present unjustifiable, harsh circumstance for that applicant, then of course they need to grant them that leave outside the rules. But how can they grant the leave outside the rules when you have not presented your situation, a picture that enables the Secretary of State or the caseworker to make a favorable decision on your behalf? So the next section, I'm going to look at what is exceptional circumstances and what is compelling circumstances. But before that, I want to acknowledge those. Very soon I'll open the phone lines for people to ask questions. I'll put the phone lines on the board so that people can ask questions about what I'm discussing tonight, or obviously what anything that is about law that I have the competence and the knowledge to answer. I will make sure that when people ask these questions, I can answer them on this platform because it's free legal advice. So I'm going to acknowledge viewers tonight. I've seen Benjamin Azu Emeje, Fisa, I salute you, watching tonight. I have Emmanuel Say, Inche Okwa. I have Nana Frima, our favorite fan who has been supporting the program every time. Thank you so much, Nana Frima. Thank you for the update. God bless you. I have Kofi Amanten, or say good evening, Mr. Thomas. Kofi Amanten, thank you so much. You're also one of those people who is always here to support this program. I have Agnes Aqua watching. I have Tina Tomakru all the way in Ghana, Accra, watching tonight. Linda Adomako, excellent program, very educative. Thank you, Linda. I have Sika Opon Mensa. Probably this is the first time I've seen you on this platform. Thank you so much for joining us tonight. I have Clement Quaten, who is watching. I have Ernestina, who is also watching. He's a lawyer, thank you. I have Fred Asare watching. Rosemond Awudui also watching. I have Nana Amadankwa, who is watching tonight. Rosemond Awudu again, he said, okay. I have Odo Pukua General, who is also watching tonight. Please, if you are watching, you can put a comment and then I will quite rightly acknowledge you. I have our famous MC Chaka, Mr. Joseph Nikwe, who is also watching. I have Dora Fupong watching. I have Carol Brown watching. I have Nana Ajwa Musea watching. Bismarck Adu Pong watching. I have Bismarck Adu Pong. Evers Amponsa watching tonight. Gabriel Banakori. Thank you, Gabriel. You also you are here all the time to support the program. God bless you. So I have Ophelia Ankama, who is also watching, and Riafo Frimpong. Yes. Thank you all for watching. I'm going to open the phone lines very soon for that if anybody wants to say anything or ask any question, they can ask the question as I'm trying to get my phone lines ready so that I can just put the phone lines on there. Yes, so if this is if you have just joined us tonight, I'm looking at those who have lived here for 20 years or those who have lived here for less than 20 years, but they have exceptional circumstances. How they can make application under the private life route, which is a 20-year residence. I am not talking about those who have lived here legally for 20 years. Those who have lived here legally for 20 years or less. And I'm taking my time to explain some of the things that I'm talking about are quite sensitive. But the fact is that everything that city law solicitor does on this platform is within the confines of the law. I have quoted that law for people who want to check, can go and check how you can demonstrate to prove your residence. Because that application will fail if you don't show that you lived here continuously for 20 years. I have whenever I come here, I always make sure that I support my submissions with the law, so that people who want to go and check can go and check. Because sometimes people either don't know what they're doing or they get deceived, and then we have most of these applications failed because they are quite complex in nature and requires presentation of unique circumstances in order to be able to adduce that outcome that you're looking for. So this is quite complex area of the immigration rule. This is not one of those cases where you have a child and you simply make application. But I'm taking my time gradually in order for people to understand, knowing the difficulty that this entails. So I have looked at, one, how your continuous residence illegally can be broken. I have looked at how you can show that you have lived here for continuously. I have looked at those suitability grounds that could result in your application being refused. And I've also looked at misrepresentation. And gradually, I'm looking at those who can also make applications outside immigration rules if they have been here for less than 20 years and they have exceptional circumstances or compelling circumstances. Because, as I've said, the law makes it clear that when the caseworker has looked at your case and you don't meet the rules, then if refusing the application present unjustifiable harsh consequence for you, then leave should either be granted on Article 8 grounds, which is the European Convention on Human Rights, or outside the immigration rules, based on either exceptional circumstances or compelling factors. So you have all these three areas to play around it, to present your case in such a way that the Secretary of State can issue you leave to remain. So when it comes to the exceptional circumstances, you need to present, for example, some of you either had brain tumor. There are some of you, may have some mild stroke. Some of you may have all kinds of serious illness. Some of you don't have anybody that after you have lived here, and I must make this point. Yes, most times the guidance makes it clear that because you've lived most of your life wherever you came from, you can safely go there. Mere saying that living here 20 years or less means that if you go there, you are not going to be able to integrate, or normally not worse. But somebody who, for example, is sick or had some few, is going on the treatment here and there, and doesn't have family members back home, it means that this person, even though he has lived here for less than 20 years, he presents exceptional circumstances. He said that he should be entitled to make application within paragraph 276 ADE, because that person presents exceptional circumstances. Or there are those who have perhaps lived here for less than 20 years, but on articulate grounds, maybe they are in a relationship with someone. Recently, I was talking to a prospective client who is in a relationship with someone, and he's the one that taking his children to school. So this person obviously have established a family life with those children and their mother because of the fact that he's playing a role in their life. So this clearly is an example of articulate circumstances. Therefore, if you have lived here for less than 20 years, then when application is made, the Secretary of State is obliged to look at that articulate circumstances. And if a good case is made on his behalf, he should be granted leave outside immigration rules. The third option is for those who present compelling. Now, when we say compelling, there was a time one of the clients that we have to deal with had a little bit of mental problems after living here for some years. And sometimes people go through a lot in this country. And that's why sometimes we want to go all out to assess those people, knowing the challenges and the difficulties that they are going through. So this is somebody who obviously have lived here for less than 20 years and have had some form of mental disability. And the Secretary of State was making an effort to remove that person. Now, somebody like that, obviously this is a case that presents what they call compelling circumstances, because that person going back obviously is not going to have anybody to take care of him, and perhaps he was already receiving support here. So that presents compelling circumstances. And it means that under those circumstances, that person will be eligible to make application and be granted leave to remain, because the Secretary of State or the caseworker needs to look at this compelling factor. But why most of these applications fail is that it's not just by presenting the medical report. It's about presenting the medical report and explaining the difficulties. Because the case of Pavan makes it clear that when lawyers make a case under these complex grounds, it is not by quoting case laws. It's about presenting that unique circumstances that brings out all the challenges, those hardships that that person will face if that application is refused. So tonight I have looked at the 20-year-long residence for those who are living here illegally. I have looked at those compelling factors that enables people to make application outside immigration rules. I have looked at Article 8 where people have lived for less than 20 years, but perhaps by now they are in a relationship with somebody who has children. And also, I have also looked at those whose cases are exceptional. So, this is the time that I'm going to open the phone lines for viewers if they have any questions, or if somebody want to say anything, they are free to do so. At this point, I'm going to open the phone lines. The phone lines are on the screen. If you want to ask any question, or you want to make any contribution to what I've discussed tonight, or you know someone somewhere, it's probably not you, and that person is stuck, and you want to ask a question concerning that person, I am here to answer those questions. So whilst I'm waiting for people to bring in their questions, I am going to advertise our sponsor. Our sponsor tonight is CITI Law Solicitors. That is our sponsor for tonight. And I'm going to take my time to obviously go through some of the things that CITI Law Solicitors does. And if for whatever reason you have any problem in any of these areas, I am willing and able to assist. This program, as I've said, is brought to you by CITI Law Solicitors. CITI Law Solicitors is a law firm that is located at Parking. I think we have a caller. Good evening. Hello.
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 Good evening.
Good evening, sir.
I was just watching you, and I was listening to what you were saying, but I have a similar problem.
Okay.
I've been here 17 and a half years, and a friend of mine told me, oh, if you have been here for 15 years, they are issuing indefinite.
Yeah.
So I followed the person to see a lawyer in London, not knowing the lawyer didn't tell the guy the truth. So I've been refused 3 times. I've been refused 3 times, and just last week Tuesday, the immigration people came to the house. Fortunately for me, I wasn't in the house, and they left a message that I should call them. Yes. So when I called them, I asked them the reason they came to the house, and they said they were just coming to find out how I was faring, because they've got a letter from my GP that I'm not feeling very well. So I told them the way they came to the house, I'm scared, so I'm leaving the house. I cannot go back to the house.
Yeah.
So in this case, what do I do? Can I do the application again? Because I've done it 3 times.
Okay, my sister, as you have been listening to me very attentively, I've already said that if you have not lived here for the 20 years, that application is likely to fail. However, if there are any circumstances in terms of some of the examples that I have given, and they are quite, they are not exhaustive. It's probably public platforms, so you might not be able to. I'm not expecting you to give me your personal information in terms of your medical.
Maybe I have to book and come and meet you personally in your office.
Yes. The reason being that that 17.5 does not entitle you to make application under the 20-year rule and be successful on that grounds alone. But you could be successful on compelling factors, exceptional circumstances. And it depends on how you present that unique circumstances. That is only unique to you. And if that is not raised in the application, the caseworker doesn't know anything about that. And that's why once they have considered the 20 years and you don't meet it, automatically they will refuse the application. But if there were other things that you put in there in that application, then they are obliged to look at it and give quite credible reasons why they should not take those other factors into account. And most times, if you present a picture that is difficult for them to give quite credible reason to counteract it, then the absence of not refusing means that they have to give you the leave to remain. So I will ask someone to put our phone lines on the Facebook page, and you can take the number. I'm going to also mention the number. And then maybe you can come for consultation, because I must admit that these cases are complex in nature and must be handled with care. And I don't seek to blame anybody for not being able to assist you in the past until I've taken you through everything that I need to know about your circumstances and be able to confirm whether you have grounds in succeeding or not. And I'll always be upfront with those who cannot succeed, rather than just making fictitious applications. So just take our number, okay? And you can be in touch.
All right. Is the number 0777-2104-967?
Yes, that is my mobile number, yes.
All right, okay. I'll call tomorrow and book an appointment.
Thank you.
Thank you very much. Thank you.
Okay, bye-bye.
Bye.
Please, if you want to call, I know somebody has called on my mobile, you can call the studio lines, because the studio lines are connected to the studio. If you call my mobile phone, I'm not going to be able to talk to you now. I can see somebody calling the mobile phone, please, if you can call the studio line is on the screen, and once you call, I'm going to answer your question. Tonight has been quite nice to be here to give hope to those who have lost hope, and to also be real with people the difficulties that they will face if they don't have what it takes to make these applications. At this point, as I've said, I just want to do a short advert whilst waiting for people to come in with questions, and then I will leave the studio. So, CITI Law Solicitors is a law firm located at Barking. We are very, very close to the Barking station. Once you come out of the Barking train station, you just have to turn right. You find some KFC there. You can sit there and have some KFC, and from there you turn right and walk to the office. The building is Barking Enterprise Center. Our office address is Unit 113 and 122, Barking Enterprise Center, 50 Cambridge Road, Barking, IG 118FG. Our phone numbers are 020-3355-0782. Our emergency contact number is 0777 777 210 4967. 07777 777 210 4967, and the office number is 020 3355 0782. We specialize in numerous areas of law. Last week I was doing consumer law to assess those who have had their bank accounts frozen or closed, and what they can do to reinstate those accounts or get compensation. Today I've been looking at immigration. That is one of the areas that we specialize in, and most of you will testify the results we've been producing for those of you who have been using our services. We also specialize in employment law. If you have been dismissed, most time people get dismissed, but behind that dismissal there could be discrimination, racial discrimination, disability discrimination, pregnancy and maternity. So most times when you are dismissed, within the first 3 months you are entitled to present your case to the employment tribunal after having conciliated with ICAS. So if you have had any problem with dismissal and you want advice and it's not more than 3 months, you can always contact us. If you are having bullying and harassment and intimidation at the workplace, we are here to assist you. If you are an employer and you want to operate within the confines of the law, so you want an employment lawyer, or if there is a claim against you as an employer and you are defending it and you need a lawyer, we are here. We represent both defendants and claimants. We are here to assist you with your business. And if you are an employee who have been unfairly dismissed, we are also here to assist you. We do most of these cases on no win, no fee basis, what they call conditional fee agreement. So we are saying that if for whatever reason you have any of those employment disputes or problems and you want to come to us, we are here to assist you. Family law. Under the family law, we are not just solicitors specialized in family law. We are family law accredited. It means a lot. It means that when we are dealing with your family law case, you have the apex of a professional because we are family law accredited. Matrimonial matters, divorce, child arrangement order, non-molestation and occupation order, If you are not being given the opportunity to see your child, you probably have to look at making child arrangement order. If you are suffering from domestic abuse, probably you need non-molestation order in place. We specialize in all these areas of the law, and we are very capable to assist you if you ever wanted us to deal with your case. Personal injuries and clinical negligence, we also specialize in personal injury. Those of you who have had accidents at work, those of you who were driving and are involved in an accident, or passenger in a car which has an accident. If you want for NHS treatment and there is clinical negligence, we are also here to assist you. Commercial disputes and civil litigation, those of you who own businesses, if you are owed money, we deal with all these cases. Housing law, housing disrepair, you will normally be entitled to compensation if your house is in a very bad disrepair state and your landlord have refused to undertake those repairs. We can assist you. Again, this is also on conditional fee agreement. Consumer law, I took my time to explain consumers' rights in terms of their bank accounts being frozen or closed. If you have any consumer law problem and you want us to deal with it, we are also here to assist you. And finally, media and entertainment law. If you have a copyright you want to protect, we are here to assist you. So tonight, I've been privileged to have you to join our program for tonight. On Thursday, we are going to have the tree session with MC Chaka. Before I go, let me see if anybody has just joined us, then I can acknowledge the person. I am very privileged to have all of you on board. Tonight we'll be looking at those of you who have been living here illegally. If you have just joined us, when I leave the studio, you can say what and listen to this video. It will help someone. Those of you who are throwing away money, making applications here and there, without understanding the basis of succeeding in that application. And lest I forget, these applications are also categorized under the fee waiver. So it means that most times, if you are not the one that have so much money in your account, they are more likely to be entitled to a fee waiver. So don't get deterred. There is a way, and that way is prosperous, because you have nothing to lose. You can do this application under the fee waiver scheme. So I've been looking overall, those of you haven't lived here for either 20 years or less than 20 years, and you are confused, you don't know who to turn to, where to get that right advice to progress your case. I have taken my time to explain what you can do. In summary, before I go, 1, you should have lived here for 20 years under paragraph 276 ADE. Your residence should not have been broken, and that's why they want you to show proof of address. I have discussed the case of Sultan Mahmoud, who says that even if you were working illegally in somebody's name, you are entitled to rely on that document to show your continuous residence in the UK. This is a law. It's not fiction. And I know most of you are in that situation. And last time I was talking to somebody, oh, lawyer, that's my Ghana people. And what Abeka say a fraud? It's not fraud. It's the law. Because they want you to show, do disclosure, how you've been living here for 20 years. That's all that you need to do. If you're going to church, let them testify. There are various ways of showing. If you don't show it, you put in that application 20 times, trust me, it will be refused 20 times. Because that is the law. If you don't meet the requirement, you will be refused. And that's why it's important that you take proper advice. And for those of you who don't meet any of these requirements, you might have some exceptional circumstances, some sickness. You might have a relationship with somebody at the age grounds. And these grounds means that if these applications are refused, even though you don't meet the 20-year long residence, it might present unjustifiable, harsh consequence. And it's for that reason, Secretary of State's hands is tied to grant you that leave. But you need to present that picture that makes it clear that you are eligible to be granted that leave. And it is for that reason that I've taken my time to explain all these things tonight. But I must acknowledge these people who have just joined us. I have Emmanuel say, he said, good job, thank you very much. I have Dora Afari watching. I have Tahiru Haruna, who is also watching. Tahiru Saruna, this is the first time I've seen you here. Thank you so much for joining us. I have Sat. Sat is also watching. Thank you so much, Sat. I have Francis watching. Thank you, Francis. I have Eunice Asare Pabi also watching. He said, thank you very much for the enlightenment, son. Eunice, thank you so much. I have Joe Chaka, good job, lawyer. Joe Chaka is one of us. He's the host for this program on Thursdays. I have Shekabi. Shekabi is also watching. Please, if you are watching and you want me to acknowledge you, you can simply put a comment. I'm just about to leave the studio. It's been privileged to have you guys all tonight, and I'm very, very grateful to you for joining us tonight. On Thursday, we are going to be here. I will take my time to explain this well detailed in tree with the help of MC Chaka for people to know their right, because people need to know their right. The law is there. Provisions are made in the law for these people. But lack of knowledge, the Bible says that my people perish. Most people are perishing. They are stressed. Some are falling sick because they don't know their right. Please share this video to assess somebody who is going through this. And I want to end by saying that I'm so grateful for all of you who have been with us tonight. God bless you all. God bless you. Thank you.